Let me permit to mention for correction, my lord. Infirmity MB for correction. And my lord, two admission here.
Admission?
Admission. One correction and two, my lord, admission. Infirmity MB matter.
Lordship, may I permit to mention one FMET MB matter for inclusion in the list, Lordship. For admission, Lordship.
You give it. I cannot assure you whether it will be taken up or not.
Lordship, urgent stay is required as because the execution proceeding has been filed by the opposite Lordship.
May I be permitted to mention the matter?
But let it appear within first 10 matters.
Yes, yes.
Is that-
May I be permitted to mention?
Great.
This second appeal, section 5 application pending, where lordship can submit. Accordingly, I am mentioning it.
For section 5?
Yes.
Yes.
So one motion matter, Lordship, I filed it day before yesterday, Friday. It is, I had mentioned you before your Lordship on the last occasion, but the file has not come
Is
before the
there
court.
any caveat?
No, there is no caveat. Caveat has been checked, but there is no caveat. Lordship, motion matter, Lordship, it can be taken up tomorrow
Let us see if it can
At
be
the-
taken
at
up.
the-
Yes, give it.
at the top, Lordship, kindly, because there is an urgency of the interim order and all.
Yes, it is.
So can it be taken up within the 10 matter?
Let's see tomorrow because time is very short.
That's
Item number 1.
Yes, sir.
No, sir, my lord, I am not.
This is not your matter. Okay, not today.
This is my matter, but I have not mentioned it for any correction.
Correction এর আছে।
I have not mentioned it.
কি correction আছে? So is there any mistake regarding paragraph number 2? Instead of learned civil judge, it should be junior division. Okay, it will be junior division. Yes, record and order. The matter is put up for necessary rectification. In order dated 16/12/2025, paragraph 2, it is mentioned civil judge, senior division, Siliguri. Let it be rectified and made civil judge, junior division. Stop. Other contents of the order dated 16/12/2025 remain unaltered.
Not the last part of the order. Not that requires a stay on the impugned order, not
Let
on the
me see.
impugned proceedings.
Yes.
Paragraph 7 of the order.
Miss case.
Yes, my lord.
So that miss case was stayed.
Yes,
Miss case means that is
in which the impugned order was passed.
so that
However-
is,
However, my lord, that would create confusion because while the impugned order, the miscase was disposed of. So there is no miscase at this point, my lord. So the stay is required on the impugned order. That is precisely my prayer as well. In the
miss case, stay of order.
yes, my lord. Stay of the impugned order.
Order dated?
My lord, 4th of November, 2025.
Yes, record and order. Learned advocate for the petitioner is present. The matter is put up for necessary rectification. Learned advocate for the petitioner submits that in paragraph 7 of the order, it is not mentioned that there shall be stay of order dated when?
My lord, 4/11/2025.
4/11/2025 of miss case 32 of 2014. Thus, let necessary rectification be made and let order dated 4/11/2025 be incorporated in the said portion. Other contents of the order dated 18/12/2025 remain unaltered.
I'm deeply opposed.
Items. And for the applicant.
Item 3, FMS 68.
FMS 16.
Yes, hence this appeal stands disposed. Judgment and award dated 31/8/2019 passed by learned additional district judge Malbajar Jalpaiguri in MSCC case number 323 of 2017 stands modified to the extent that the appellant claimant is entitled to compensation of rupees 34 lakh from respondent number 1, United India Insurance Company Limited. Stop. However, there will be no order as to interest on excess amount as observed above. The respondent number 1 shall pay the appellant rupees 34 lakh less the principal amount already paid in terms of the judgment and award of the learned trial court. In the event the order of the trial court is not complied, the amount as directed by the trial court along with interest plus rupees 12,35,532 shall be paid. Such payments shall be made within 5 weeks from the date of communication of this order.
Yes.
Yes, disposed. Yes, shall it be paid to the party or deposited? It has to be deposited
It is
before the register.
Before the
Yeah,
race.
whatever, it will be there, deposited before the register. Okay. Yes, next. Item 4. Yes. Hence, this appeal stands disposed. The judgment and award dated 27th March 2024, passed by learned additional district judge, First Court Siliguri, Darjeeling, in MSC case number 106 within bracket 8 of 2014, stands modified to the extent that the appellant's claimants are entitled to compensation of rupees 11,55,200 from respondent number 1, along with interest at the rate of 6% per annum from the date of filing till today. Such payment shall be made. Instead of payment, it should be such deposit shall be made within 5 weeks from the date of communication of this order. In the event the amount awarded by the learned trial court is already paid, the balance amount shall be deposited. Next.
Lordship, I beg to appear for the appeal. I am for the defendant respondent's plot. Milos, earlier occasion they submitted a judgment, Milos, I was not submitted the.
Anyway, you want to submit? Shall I pass the order?
Milos, only one small point, the judgment that they referred on the previous occasion, Milos.
Anyway, give the judgment, then tomorrow I shall pass.
Because I am not supplied with the copy.
But I have to pass the order either today or tomorrow.
My lord kindly passes order, Milos.
So today I shall pass the order.
Lord.
Yes, hence this application for substitution being Can 2 of 2025 filed by the petitioners. Appellant stands allowed after condoning the delay and setting aside abatement. The name of appellant Gobinnath Burman be deleted on account of his death and the names of legal heirs as mentioned in paragraph 2 of the petition be incorporated. Such amendments shall be carried out within 2 weeks after vacation. As application for substitution after condoning delay is allowed, the application for dismissal of the suit on grounds of abatement being Can 1 of 2025 stands automatically dismissed.
Deeply.
Ultimated 3 p.m.
I'm responding seeking 1 day adjournment.
Yes, this is for recalling of that order.
No.
It's a new matter.
I'm seeking 1 day accommodation.
Item 9,
Item 9.
not today.
I am for the opposite party.
In this case, my lord, we have to file opposition in this case, my lord.
For divisional application, why is the scope of
Yes, my lord.
opposition?
Yes,
It is only on the question of law.
yes, my lord.
Yes. The matter is admitted and thereafter notice was sent to them.
There is suo motu appeared.
You want to appeal, my lord, last occasion, your lawsuit. please.
Anyway, whatever it is, what is the order under this revision?
Order under the revision is that the kindly come to page number.
Yes, improved order, 8/9/2025.
Yes. Yes, my lord. Kindly come to the page number. Page number. Page number 30.
Page 30.
Yes.
Yes.
In this order, the petition under order 22 rule 4 of the CPC for substitution of the different number 4, 24, Gopal De Sarkar was rejected. But at the time of filing the, during the time of impugned order, kindly come to the impugned order. There was a direction on the last occasion to file a amended plaint, and they had filed the amended plaint on that date, which has been endorsed with objection, which is which can be seen in page number 34. Why the objection was given? Because in spite of the fact that
Anyway, so let them file affidavit in opposition.
they may file, but the case fixed on fixed in 5/1 to 2024 for DW, can list order
My
of.
lord, if there's a, my lord, there's a,
The matter has to be hard on affidavit.
Yes.
So in the meantime, don't proceed.
my lord, may I, my lord, the fact of the case, my lord, what the submission has been made by my learned senior
The
friend.
question is, you want delete by affidavit or you don't want to delete? If you want to delete by way of affidavit, file your affidavit after vacation. In the meantime, don't proceed before the trial. This is the alternative. Yes, record an order. Learned advocate for the petitioner and learned advocate for the opposite party are present. The matter is taken up for consideration. Hard learned advocates peruse the order under revision. On perusing the petition and after hearing the learned advocate, this application is admitted as learned advocate for the opposite party prays for leave to use an affidavit in opposition. Such leave is granted Let affidavit in opposition be filed within 1 week after vacation. Reply, if any, within 3 days thereafter. Liberty to mention the matter before the next available circuit. Pending hearing of this application, there shall be stay of further proceedings entitled suit number 143 of 2007 before learned Civil Judge Senior Division, Jalpaiguri Shodor, shall remain stayed for a period of 5 weeks.
Yes, sir. I am for the petition. If, the present revision application has been filed before your lordship against the order dated 27th of August 2025, which allowed this substitution petition under order 22 rule 3. The gist of the
Your application is allowed.
no, the plaintiff's application, the brief of the case is that there was a sole plaintiff who has filed a suit for declaration injunction against the defendant.
Yes.
During the pendency of the suit, the sole plaintiff died.
Yes.
Then one person, Abul Kalam, filed a petition regarding substitution with a claim that he has a registered will. But the same will was been under challenge by the defendant and is still pending before the district court. And during, without acquiring any right,
Is the order passed?
the order is at the end of the petition.
What is the error in this order?
Lordship, the legal representative is under challenge. So
But it is
order-
legal. The executor is impleted subject to the
But
result of.
subject to the result,
Yes,
what will be the outcome of the probate will be affected.
yes, yes.
Subject to the rights also, subject to the rights being a final decision from the probate. So if
Whatever it is, he has to
if-
represent the estate of the deceased person.
deceased person.
Yes, so,
No, but
so this is the
but
sole plaintiff.
sole plaintiff died.
So
And
now the question, you are the defendant.
I am the defendant, I am challenging his legal representative status.
No, there's nothing.
Kindly kindly produce the order 22 rule 5. It has to be determined whether the
See,
legal representative or not. My lordship knows that the probate case, once contested in the suit, it takes a turn up as all the decisions which will be taken in the probate case will be taken as a status by the probator legati. And order 20, by
Yes,
finding-
yes, that provision is there.
Yes.
Yes, record an order. Learned advocate for the petitioner is present, or learned advocate for the petitioner. This application is directed against the order dated 27/8/2025, passed by learned civil judge, Junior Division, Additional Court, Shodor, Kuch Bihar, entitled suit number 53 of 2017. The ground of challenge in this application is that the learned trial judge has pleaded the executor of the plaintiff, executor of the plaintiff as his legal representative. Learned advocate refers to the provisions contained in order 25 of the Code of Civil Procedure with regard to determination of question as to legal representatives. Upon perusing the order, it appears learned trial judge has disposed and allowed the application for pleading the executor in the suit on the date of the sole plaintiff is as follows. Upon considering the provisions contained in order 22/5 of the Code of Civil Procedure and considering the facts of the case and the evidence assigned by the learned trial judge. This court does not find any ground to interfere in the order passed by the learned trial judge. Thus, this application stands dismissed. No, you see, unless there is a caveat, they are not bound to serve you. Yes, what is the urgency?
Urgency, this is the same, on the same facts, same order. So in the last
Okay,
order. So there is a stay.
Submit a copy, let him file the affidavit in opposition. Okay.
An
In the
order,
meantime-
same order.
In the meantime, don't proceed before the trial.
Yes, yes.
Copy may be not today,
Yes.
tomorrow matter may be taken.
No,
The fact of the case, the order.
no, you see, if you want to file affidavit, it cannot be decided like that. Time is very limited. Yes, record an order. Landed advocate for the petitioner. First of all, you see, it is not obligatory on his part to serve you a copy. Matter can be taken up expertly also. That's because you have appeared to cut short the matter, I am granting him opportunity to serve you a copy. Landed advocate for the petitioner is present. As, what is your name? As Mr. Abhijit Kaur, which presented court submit that he intends to appear on behalf of the opposite party. Let copy be served upon Mr. Bush for taking necessary instructions. Let this matter appear 1 week after application. Necessary affidavits be filed on the date of the reopening. Pending hearing of this application, there shall be stay of further proceedings before the learned civil judge senior division Jalpaiguri entitled suit number 143 of 2007 for a period of 5 weeks from date.
This matter I am appealing for respondent number 1. I have not received the copy.
He has not, did not file the caveat also, and he is appearing suo moto in this.
Just I am
Just
receiving the.
So what is this? What is the impugned order?
impugned order, my lord, here an police help has been ordered in excess of the main order.
Okay, let him take instructions, okay?
Yes.
In the meantime, just don't proceed for the time being. Yes, record an order. Learned advocates for the petitioner is present. Yes, your name please, Mr. Partho Bhumi is present in court, submits that he intends to appear on behalf of the respondent, opposite party number 1. Let a copy of the application be served upon Mr. Bhumi for taking necessary instruction. Let this matter 1 week, let this matter appear 1 week after vacation. Affidavits may be filed in the meantime. Pending hearing of this application, there shall be stay of the order dated 24/11/2025 passed by learned civil judge senior division Jalpaiguri entitled suit number 148 of 2025 for a period of 4 weeks.
Same matter.
Same matter.
For respondent number 1.
It is against the
Self-
order.
Self-same suit or different
No,
suit?
the self-same suit, but order of district judge. That was the order of learned trial judge.
What is the order?
Order dated 38/2025. whereby the order of
23-9. 23-9,
23-9, huh? Yes, yes. Paying for stay of injunction order has been refused.
So you have prayed for status quo before the trial court.
No, status quo, it was a contested hearing in the status quo.
Yes.
The contested hearing was there,
Yes.
but learned trial court did not pass the order. But passed an order of status quo in the meantime,
Yes.
in interim form.
Yes.
Although hearing heard by both sides. And there, which has been challenged before the Honorable Appellate Court, before the district judge. And on the fact that there is a specific avertment by the plaintiff, defendant,
Yes.
that the suit property is not the suit property. They are not constructing on their own property, not on the suit property. Property is it was a partition suit, and they had filed the partition suit in respect of 5 decimal of
So
land.
what interim did you see? Trial court gave an interim protection. Against that you went before the appellate court.
Yes, my lord.
So what interim relief you prayed for? An interim relief of status quo was given in favor of your clients, of your learned friend's client. Okay. Against that you moved the appellate court.
Yes.
So what was the relief you claimed before the appellate court? So what is the error in the order passed by the trial court?
Error, that I am saying. Kindly come to the trial court, sir. Page number.
You are the respondent number one. Not
Kindly
yes.
Kindly come to the page number 41.
Yes. Page 41.
Yes.
Yes. Let me see what is the order passed.
Yes.
Yes, so there is a direction to maintain status quo.
Direction in maintain status quo, but in considering that, kindly come to the page. At the time of hearing of the hearing, learned advocate appearing for the defendant number 3 has submitted the defendant number 3 is constructing his residential house in obtained section from other.
No, whatever it is, the status quo be maintained till disposal of the suit.
No, the status quo is stated till the next hearing.
Yes.
Interim form uncontested. When it is contested, it is passed in interim form. First, it is a contested.
That has been extended.
That is that letter, but in the impugned order, it is passed in interim form. And also that the fact remains, the WS has been filed, and it is specifically averred that the suit property is, he had filed my father's property on 5 decimal of land. But father had already gifted 600
Next date of hearing is the next date of hearing of this.
of this petition for
So 59/2025.
yes,
So 59/2025 was extended.
that was extended.
So what is
That
the
is
difficulty?
extending. They are
What is the difficulty?
no difficulty is that he is defendant. The defendant is constructing his father's. The plaintiff has sought for partition of the father's property,
Yes.
but father had gifted 600.
That will be decided at the time of trial.
No, no, deeds are not challenged till date. No deeds are challenged. No deeds are challenged. Kindly show the deeds are challenged. Till date, they did not challenge the deed.
What you at present?
At present, I am showing the judgment of the.
No. Question is what relief are you seeking now? You see, you are already protected by an interim order.
No,
If there are subsequent development in file.
No, I have not sought for interim order. They had sought for interim order.
Then I think there is nothing. This is a justified order.
No, my lord, I will show.
No.
No, I will show the judgment because
You-
when there is a registered deed in
Yes.
favor of mine, that has not been
Very well,
challenged.
Very well.
That has not been challenged.
Court is fully empowered to direct status, whatever you have.
No, no, no. Without determining the status supreme, I am going
Wait, just a minute. Let your learned friend come. Learned advocate for the petitioner is present, as Mr. Bhumik, Partho Bhumik is present and submit that he intends to appear on behalf of the respondent number one. Let a copy be served upon the respondent number one, stop. And all, upon Mr. Bhumik representing respondent number one, let copies be served upon all other respondents within 1 week from the date of the vacation and affidavit of service filed. Let this liberty to mention the matter before the next available Saturday. Yes.
Yes, madam. Kindly come to the impugned order. In the impugned order, my lord, although the commissioner report has been rejected and the petitioner's was specific claim to appoint the separate commissioner because he had a connivance with the other party, but although rejected, the same commissioner has been.
Rejected. So, you are challenging this.
I have challenged the order on the,
Order of rejection.
no, not rejection. Appointment the same commissioner. Kindly come to page number 37. Our specific
No.
allegation was that the commissioner was mixed with the other party.
Where is that?
Application is that page number 41. In para 5, we have stated that the plaintiff is the client of the survey commissioner. Survey commissioner himself stated before the learned trial.
No, where is that allegation that he is mixed with other?
Para 5.
Para
In the
five?
said report, survey commissioner stated that the plaintiff is the client of the survey. I am showing the report. And we are paid for separate appointment.
That yes, appointed on the same survey commission.
Yes.
So if the survey commissioner enter into inspection.
Yes, kindly come to the report.
No. Pursuant to the.
No. Till now, till date, inspection has
Yes,
not.
record an order. Learned advocates for the petitioner is present, her learned advocate for the petitioner. This application is directed against order dated 8/9/2025, marked by learned civil judge senior division, Jalpaiguri Southern Court, ETS 160/2007. So the response of the petitioner is this: although the commissioner's report is rejected and there was a prayer made by the plaintiff to appoint a separate commissioner on the ground.
Defendant, we are the defendant.
By the defendant to appoint a separate commissioner on the ground that the plaintiff was the client of the Survey Commissioner. The prayer for change was not accepted by the learned trial. The facts and circumstances, this court is of the view that this application should be admitted. Hence, notice be issued among the opposite parties. Within 1 week after vacation, an affidavit of service be filed. Let liberty to mention this matter. 1 week after vacation, on completing the service before the next available circuit. Pending hearing of this application, there shall be a stay of the order dated 8/9/2025, passed by learned civil judge, senior division, Jalpaiguri Sodor Court in TS 160 of 2007 for a period of 4 weeks from date.
This is appearing for the first time, although I'm not pressing for an interim order. But I'm challenging, I'm being partly aggrieved by the order passed by the district magistrate, being the appellate tribunal under the seniors welfare of maintenance and welfare of parents and senior citizens act. Now, after 108 is the certified copy of the order. There were 2 rooms and 1 shop room, out of which only the possession of the shop room was asked to be handed over to the senior citizens one. And the maintenance was enhanced to 8,000 from 5,000. I'm aggrieved by that. The next page of the order, I will file the report wherefrom it appears that presently they are not residing in the house of the senior citizen, but still they have put the rooms under lock and key. The shop room has also not been handed over till date.
So these are the son and daughter.
Yes,
of the
daughter-in-law
of the
petitioners, the senior
number.
citizens, parents.
Okay, number 1 is the son,
Number 1 is the son, opposite by
Number
number
two is
2
the
is the daughter-in-law.
daughter-in-law,
Yes, ma'am.
and number 1 is the father and 2 is the mother.
Yes. No, I'm although not pressing for any interim order, let me serve and come back.
Yes. Advocate for the petitioner is present, petitioner. This application is directed. Yes, order dated 30/10/2025. Passed under by the appellate.
Appellate tribunal, office of the district magistrate and collector, Jalpaiguri.
30/10/2025. Passed by the district magistrate Jalpaiguri in case number, appeal number 2 of 2025 under section 16 of the Maintenance and Welfare of Parents and Citizens Act 2007. Hearing the larger advocate and producing the petition, this purpose of the view that this application will be admitted, thus I admit this application. Let notice be issued among the opposite parties in 1 week after vacation and affidavit of service be filed. Liberty to mention the matter before the next circuit bench after completing the service.
Okay, I beg to appear for the petitioner. Petitioner before your lordship is the defendant in a suit filed by the plaintiff for declaration.
Yes.
Initially on 23rd March, an interim order of status quo was passed by the learned civil judge, Junior Division, Jalpaiguri.
Yes.
Thereafter, lordship, next date was for 5th June 2025 for framing of issue.
Yes.
Thereafter, next date was 5th March 2026, lordship. A
Yes.
long gap of 6 months, lordship.
Yes.
So I am paying for expeditious disposal of the matter.
When is this suit filed?
Suit filed in the year 2025. But
Whatever expeditious disposal you want,
because,
you see,
but injunction application should be heard.
no injunction application is pending.
Yes, Lordship.
When is the date fixed for that injunction application?
Injunction accommodated. March 5/3/26, Lordship,
5/3,
26.
where? Where is that order fixing the date for injunction? 5/3.
Lordship, fifth paragraph 5, Lordship.
Paragraph 5. Five is this, where is that order, injunction?
Page 23, Lordship.
Page 23. No, regarding injunction order, that status quo to continue till disposal of the suit, where is that order?
22, Lordship, 21 page.
Right, 22. Oh, the status quo order, you see, that is already there, that is disposed.
Yes, Lordship, that is disposed.
So how that injunction application is to be disposed? Because injunction application is already disposed.
Disposed of.
And the suit is not also very old suit, 2025 suit. The date for PH is fixed in, you see, in the month of March.
March, Lordship.
So
After lapse of 6 months. Lordship.
whatever it is, you see, I do not find any inordinate delay of the trial court. Yes, record an order. Learned advocates for the petitioner is present, and learned advocate for the petitioner. Learned advocate for the petitioner submits this application is filed for a direction upon the learned trial court to dispose of the title suit number 177
Of
of
2025.
2025 expeditiously stopped. Upon perusal of the record, it appears that the suit is instituted in the year 2025 and the learned trial judge has already fixed 5/3/2026 for PH stop. Thus, this court does not find any delay of the learned trial judge in proceeding with the suit. Stop. However, as it is submitted by the petitioner, learned advocate for the petitioner, who is a defendant in before the learned trial court, that the order of the injunction application is already disposed and the petitioner defendant is suffering from an interim order. This court requests the learned trial judge to expeditiously to dispose of the case within a period of 9 months from the next date fixed without granting within a period of 9 months from the next date fixed.
Without granting any unnecessary.
There is no unnecessary adjournment, I find from the record. Very expeditiously, the suit is being proceeded with. So what else do you want? 25 case PH is already fixed, 2026. From the next date fixed, 9 months from the date, from the next date fixed.
Deeply applied.
Fixed by the date. Appear for that.
On the last occasion, Malad was pleased to hear me out. I've already completed my submissions. It doesn't matter. Today, my learned senior counsel for the other side.
You have submitted your written
I have-
notes also.
I have also submitted.
I'll submit it tomorrow, Malad. Could not prepare it. I'll finish it
But I'll
today.
submit, time is very short. So today you conclude your.
Yes, I'll conclude it.
Tomorrow just submit the
Yes,
written notes.
Well, then, I have also prepared a list of judgments. I'll submit it tomorrow along with the.
Yes,
Whatever it is, then tomorrow I have to keep it at 4 PM or something like that.
Yes, I also won't be available in the second, later part, so.
No,
It is fixed at 2.
my learned friends, advocate on record comments, hand it over to your lordship.
Something has to give in reply also, because
Yes.
after the opposition reply, but only on the points of law, not the
Yeah,
details.
it's only on the point of
Only
law.
clarification and point of
Yes.
nothing.
I'll have to fix it at 2 PM tomorrow again, my lord, then I can give a short reply.
Anyway, let me see how far you learn it and proceeds.
My lord, has the paper book with your lordship? Yeah, my lord will kindly first come to page 150 of the paper book where the substantial questions of law has been framed.
150.
Yes. Now, my lord, I'm drawing the lordship's kind attention to the first question of whether the plaintiffs and the defendants were governed by the Mohammedan law of inheritance or Dayabhaga school of law at the time of the death of the father of the plaintiffs. My lord, I have failed to understand, my lord, how this point has any relevance to the case before your lordship. Now
So the date of death is already.
Should not be father. it
No,
should be
what has
principal.
happened, my lord? The plaintiffs in the plaint case have said they have derived title from one Taslimuddin's sons. Now, Taslimuddin is the father of the defendant number 1, and they have claimed ownership by way of purchase.
Registered.
So, law of inheritance, whether it governs the plaintiffs or not, in my respectful submission, is of no consequence to the instant case.
Anyway, but this is there, fixed
Yes.
by, filed by the, framed by the division bench.
Yes, and my lord, the next part, at the time of the death of the father of the plaintiffs. Now, the father of the plaintiffs, my lord, the death of the father of the plaintiffs
No.
is of no consequence because I am claiming the defendant number 1, who is now deceased, was claiming ownership by way of inheritance from her father, that is Taslimuddin. So the death of the father of the plaintiffs will not affect my right in respect of the death of my father.
You see,
Final.
that means if you inherit from your father
Yes,
and your father inherits from the Taslimuddin.
my father is Taslimuddin.
No, your
Defendant number 1's father is Taslimuddin.
defendant number 1's father is Taslimuddin.
Yes, and defendant number 1,
2 and 3.
2 and 3 are the sons of defendant number 1, so their mother.
Grandfather.
And
maternal-
Taslimuddin is the maternal grandfather.
Of Taslimuddin, the right flows
Flows to the
Okay.
defendant.
to the defendants.
Yes.
So now the question comes is this, whether the right has from Taslimuddin has flown to the defendant.
Yes, but
That is the question of law.
but the question of law, to my limited understanding, is the death of the father of the plaintiffs. I am not the plaintiff.
To be defended. Defendant number.
And the plaintiffs, whether the plaintiffs are governed by Dayabhaga or Mohammedan law, my lord, is in my respectful submission again of no consequences to the case. So this question of law, my lord, now if your lord,
Another question can be framed whether the plaintiffs and the defendants were governed by the Mohammedan law of inheritance.
Predecessor in interest. madam.
No, after at the time of death of the father of the defendant.
Predecessor, yes, predecessor,
Defendant.
Father of the defendants.
yes.
Another question of.
Yes, but that, or it can be rephrased in a manner, whether the predecessor in interest of the plaintiffs, that is.
Anyway, third question, that is whether the
Governed by the-
plaintiff, whether the defendants were governed by the Mohammedan law of inheritance or Daibaga school of Hindu
Yes.
law
Yes.
at the time of death of the father of the defendant.
Father of the defendant number one.
Father of the defendant.
Defendant number one.
Yes.
That law can, that,
Yes, yes.
that
is a
can be
vital-
additional ground.
That is a vital issue.
So, if your lordship so desires, then I will address your lordship on the point that the death of the father of the defendant, how that has affected. Because I am, because in respect of this question of law, the answers, my lord, the reply would not in any effect have any effect to the case.
No, you submit. Now
Yes.
the question is, one more question will be.
Can be found under, my lord knows, under section 100 of the CPC, the
Yes.
proviso.
Question will be
Yes,
Formulated whether,
yes.
whether the inheritance of Daibaga school of Hindu law or
Yes.
Mohammedan law
Yes.
at the time of death of the father of the defendant.
Yes,
number
ma'am.
one. This
Yes.
question will be.
This
This
can.
is the question, this is
Very
the
good.
relevant
Fine.
question.
Now you submit.
Now, my lord, what I'll take your lordship, now here the important point is the date of death of Taslimuddin. Now, the plaintiffs are claiming that Taslimuddin died on a particular date, that is 1338 BS. And our case is that our father, the father of the petitioner, defendant number one, died on 1388 BS. Now, well, for some reason, the written statement is not part of the paper book. Now, I have a copy of the written statement, my lord.
No, because you see, in second appeal, in the written statement is not incorporated in the
Yes.
paper. It is only limited.
My lord will come to my averment at paragraph 9, page 2 of the written statement, because that is where, my lord, my submission is there with regard to the date of death of Taslimuddin.
That is reflected in the issues.
Issues
by the
also,
trial.
but still I have also
Reflected in it.
taken it up. Now, my lord, I'll take,
Statement, what have you stated?
my lord, at page 2, paragraph 9. Yes, my lord, that the averments of the plaintiffs made in para 3 of the plaint is also not true, as after the coming into force of the Muslim Personal Law Shariat Application Act, which was promulgated on 1/7/1980, the Muslims of Kuch Bihar were guided by this act and not by the old Dayabhaga law. As Taslimuddin Mia died on first day of Boishak 1388 PS, neither he nor his heirs and heiresses were governed by the old Dayabhaga law in the matter of inheritance, but the Shariat law is aforesaid. Now, as per our calculation, my lord, my learned friend can also, my lord, come in assistance, that 1388 probably comes to 1981 or 82, 81. So,
Ours was 1383.
yes,
Theirs was 1380.
88. Now, my lord,
This is the case of the defendant.
this is the case of the
That is case
defendant.
of the defendant, 1380.
Yes.
Ours was 1380.
Now, my lord, I will take your lordship now to the judgment passed by the learned trial court, which is at page 84. I will take your lordship straight to the issue.
90.
Yes. Issue 7 at page 90. Thank you. Page 90, my lord. Page 90.
90.
90.
90, my lord. And this is how the learned trial court came to the conclusion that Taslimuddin Mia died during the time when Dayabhaga law was applicable to the Muslims of Kuch Bihar state.
90 issue number 7.
Yes, my lord. I'll just take some time and place it, my lord. This issue is taken first for discussion because the other issues are interlinked with the issue, as a result of which it is taken first. Now, the first question before this learned court arises is that what is the date of Taslimuddin Mia? Learned advocate for the defendant submitted that the plaintiffs are unable to produce any documents relied upon which this court can come to the conclusion about the exact date of death of Taslimuddin Mia. Learned advocate of the defendant also submitted that in Khutiyan number 319, it was stated that Taslimuddin Mia died in the year 1975 AD. Being deed number 2649 dated 25/5/1976, it was clearly stated that Taslimuddin Mia was alive and he himself transferred the scheduled property. Now, my lord, pausing here for a moment, if your lordship currently turns to page 88 once, where the exhibited documents are there. My lord is there. Now, exhibit 3 is deed number 2649.
Page 88.
Yes, my lord. Now I am again taking your lordship back to page 90, the paragraph where I was.
Exhibit 8,
Exhibit 3, my lord.
Exhibit 3,
3.
registered cell deed.
Yes.
Yes, and then para 90.
No,
Page
page 90 again, I am taking your lordship back to page 90, my lord.
Yes, this is
Now, from where I have stopped, my lord. Deed number 2649 dated 25/5/1976, it was clearly stated that Taslimuddin Mia was alive. And he himself transferred the scheduled property deed being number 1006.
That's different. Scheduled property, yes.
Yeah,
We full stop.
acha, full stop. Deed, নেই আমার ওখানে stop টা।
আমার এখানে
আচ্ছা, যাই হোক, Taslimuddin Mia was alive and he himself transferred the scheduled property, full stop. Deed number 1006 dated 17/4/1979, it was clearly stated that Taslimuddin Mia was died. It has also been stated in the plaint that Taslimuddin Mia died in last part of Ashwin 1383 BS, deed number, full stop. Yes, deed number 1445 dated 25th April 1980 also stated that Taslimuddin Mia had already been died at the time of drafting of deed. PW1 has stated that Taslimuddin Mia was alive in 1975-76. PW1 also stated that Taslimuddin Mia was the father of 3 sons and 1 daughter. PW5. Now he is the independent witness, madam. Abdul Qadir Basunia has stated that Taslimuddin Mia died in the year 1388 BC. Yes, sir. Next page, madam. PW1, Maqbul Mia stated that Taslimuddin, এটা D না? হ্যাঁ, clear না? Sorry, my lord. DW1, Maqbul Mia stated that Taslimuddin Mia died in the year 1388 BS. So the independent witness also states that Taslimuddin died in 1388 BS. So there is serious anomaly and ambiguity regarding date of death of Taslimuddin Mia. So the date and time of death of Taslimuddin Mia has been stated by the plaintiff in the plaint, that is last part of Oshin 1383 BS is baseless and not at all reliable. It is created only for institution of the suit. On the other hand, the plaintiffs have stated that at the time of the death of Taslimuddin Mia, no death certificate or any document of like nature was not preserved, as he died more than 35 years ago. But from the circumstantial evidence, they are able to succeed and establish the exact period of death of Taslimuddin Mia. They submitted that Taslimuddin Mia was died in the last part of Oshin 1383 BS, as deed being number 2649 dated clearly stated that Taslimuddin Mia was alive till 25th May 1976, as he himself transferred the property. But in deed number 1006 dated 17/4/1975 9 and deed number 1445 dated 25/4/1980 clearly stated that the date of death of Taslimuddin Mia was before 1979, as it was mentioned in the deed that late Taslimuddin Mia. The defendant has stated in written statement as well as affidavit in chief of DW1 in the schedule of land that defendants are alleged to be in possession. But they did not produce any Khutiyan, perhaps in affidavit in the chief of DW1, they stated that Khutiyan number 319 was missing. On the other hand, plaintiff submitted the Khutiyan being 319, which was exhibited as exhibit 2 in the name of the defendant number 1. The document should be produced by the defendant to establish their case, but they did not produce it because in exhibit 2, it has been clearly written that Taslimuddin Mia died in 1975, which goes against the defendant. all the PW stated that the date of death of Taslimuddin Mia was last part of Oshit, 1383 PS, except PW5. PW5 had stated that the date of Taslimuddin Mia is 1388 PS. Now it is to be decided whether the admission of the fact by the defendant in WS regarding the death of Taslimuddin Mia is reliable or not. PW Abdul Qadir Basenia was a deed writer by profession, and he drafted deeds being number 1006 dated 17/4/1979 and deed number 1445 dated 25/4/1980, in which he write in his own hand that the vendor Abdul Hamid Mia, son of late Taslimuddin Mia, and the deed being number 1445 vendor HON'BLE Mia, son of late Taslimuddin Mia. On the other end, Taslimuddin Mia was the uncle, that is Pisha Mosai of PW5 Abdul Qadir Mia, as he stated in his deposition. So it is clear before the learned court that he has a clear knowledge that the date of death of Taslimuddin Mia is in the year 1383 BS. But in cross-examination, he stated that the date of death of Taslimuddin Mia is 1388 BS on the ground that defendants are his sisters and nephews. So whatever he stated during cross-examination is not at all reliable by the learned court, and it tantamounts to willful suppression of material facts. After considering the documents, evidence, and materials available on record, it appears to me the date of death of Taslimuddin Mia is last part of Ocean.
Now, this deed writer
Yes.
stated that this Taslimuddin died in
88.
1388, and in the chief it is 83.
No, no.
No.
In
the
his
chief-
cross.
In the chief of PW, in his chief it was, he didn't die.
No,
That is
in
in
chief.
He stated it was 1388, but it was he himself who had written the deeds, which were
That's why,
executed.
that is the, yes, he has written the deed.
Which were executed, wherein he has stated the deeds which were executed by the son of Taslimuddin, wherein he has mentioned
So
the
he is
name
the
of,
draftsman.
He is the deed writer.
he is the deed
Okay.
writer.
And
Wherein he has
that deed was written by him in which year?
in the year
1980,
1979,
79, 1980.
1980,
1979.
79 and 80,
One-
wherein he stated Taslimuddin Mia as late Taslimuddin. That means he was well aware at the time of drafting of the deed that Taslimuddin Mia was already dead by that time.
Okay, in the deed he mentioned, let
Late
Taslimuddin.
Taslimuddin, those deeds were executed by the sons of Taslimuddin
Okay.
after his death.
That means Khan has declared themselves to be the of late Taslimuddin.
Late Taslimuddin. It was drafted by the same person, PW5.
Okay. And in cross
But
examination,
in his statement before the court, he states that it is not 1383 BS, it is 1388 BS. Just to favor
in cross examination.
in his cross examination, just to favor the defendant because they are related to it. He might have forgotten the document that he had already executed. He didn't remember that he had already executed that.
He did
He
not-
himself written
Anyway.
that.
He did not execute,
He
he
written.
drafted.
He is the drafter.
Now the
As per
question
whose instruction, as per instruction of the
on them,
Son of the-
of his clients or whatever
Yes,
it
Yes,
is,
son of
By
Taslimuddin.
of the parties to the deed.
Yes.
right. So my lord, now comes the question of the deeds in question. These two deeds, my lord, 1006 dated 1979 and 1445 dated 25th April 1980. Now again, I'll trouble your lordship with the list of exhibits at page 88. Now, my lord will kindly come to page 89. My lord is there. Now kindly comes to the exhibit of documents by the plaintiff X for identification.
Yes.
Now, X1 for identification, deed number 1006 dated 17th April 1978. X2 for identification, deed number 1445 dated 25th April 1980. And before these two, exhibit X for identification, deed number 2649. Now, my lord has been pleased to see defender exhibit deed number 2649 has been exhibited.
Yes,
Subsequently exhibited.
Yes, these
Yes,
deeds,
earlier it was identified. as
yes, my
subsequent-
lord,
It was-
and these two deeds were never exhibited.
No.
Which one?
1006 dated 17th April 1978 and deed number 1445.
No, whatever
Dated.
is exhibited
My lord,
will be there.
It is not there, my lord.
Takes up the earlier page.
Yes,
Malad
kindly
up page
takes
number
up.
88.
Kindly takes up.
88, Malad takes
Yes.
up the exhibit 4. The signatures of the deed writers have been
Signatures have been
already
exhibited, my lord.
It
The
cannot
deed,
be, it cannot be, the signature
Deed-
cannot be executed without the deed being executed.
the deed, if
Though
they,
at
if
that
the
point
deed,
of time, because the deed writer came later on. At the time when these deeds were exhibited, it was exhibited by the plaintiff number 1.
Anyway, this is a public document, registered deed,
Yes,
registered deed.
and the
See,
signatures of the deed writer
This
are.
is the public document, registered deed.
Yes, signatures of the persons, signature of the persons who have executed the deed.
So
Those
this deed,
signatures have been
this
executed.
deed is executed and registered in 17/4/1979.
79 and 80.
79
dates.
and 80.
So these are public documents.
Public
But,
documents.
but not taken on record as an
That is
exhibit,
also
not
taken
proved.
on record.
Question is-
These signatures, my lord, have been exhibited.
Cannot be.
It has been done in this case.
Cannot
What
be.
can be done, what cannot be done is a,
That
is
not-
separate,
that is not-
is a separate question, my lord.
That is
The
not.
law says, my lord, any document which has been admitted as an exhibit has to be recorded as an exhibit
It is
and it has to
already
be
recorded.
proved. It has
Okay,
to be
let us see
proved.
the deposition.
Yes.
Deposition, that is, these were marked exhibit after the deposition of PW
Up-
one.
After those were marked as X for identification after the deposition of PW1.
So
Subsequently-
no, on whose examination these were marked?
Subsequently.
So
my-
the deed
my lord-
writer has given the
Deed writer.
signature.
Yes.
Yes.
Okay, deed writer has given the, you
After
see, deed writer signs means that means deed is prepared by.
By him.
Yes, but the contents have not been proved.
Contents are admitted by signature of
You
Abdul
see-
Aziz Mia. He has identified.
Suppose you see, what is
Yes.
the distinction in probate? Suppose witness will identify
Yes.
that the executor has signed the probate application.
Yes.
Yes.
That is
Yes.
will, okay?
Yes.
That is the witness will identify.
Yes.
Yes, yes.
Signature of the, but witness cannot say the contents of the will.
Yes.
But so far the deed writer is concerned.
Yes.
The deed is drafted by the deed writer.
Now, my lord, kindly sees. with-
He is
That
well aware of the contents there.
So, as per the instruction.
Yes.
so
Yes.
Deed writer drafts the deed.
Yes.
So it's not that somebody has
Else has drafted the
him and tell
And
him
he has
to
only
sign.
put his signature. That is not the.
For example, an advocate also drafts a petition.
Yes.
Draft a document.
That issue
Just
already
a
existed.
moment. My lord, this deed number 1006 was executed by Abdul Aziz Mia, who is one of the sons of Taslimuddin in to the plaintiff number 6.
No, deed writer means that is the professional deed writer.
Yes. So plaintiff number 6, while giving his deposition, has also not taken the pain to get this deed exhibited.
The signature is in-
So the contents of the deed remains unproved. My lord, I'll not today, since paucity of time, my lord, I have made my submissions on this, and in the written notes of argument, my lord, whatever need elaboration, my lord, I'll place it before your lordship. My lord, can I proceed now? Because my lord, the time and that is how it is. But we are grateful, my lord has taken the pain to take this matter still in such a
Time
short
is very
time.
short.
Exactly, my lord. Now at page 92 again, my lord, I'll take your lordship again, please.
Because you see, even if I conclude, I have to deliver the judgment from Calcutta.
Yes, yes. We'll conclude from our sides.
Yes, at least do that.
Yes, and I must also thank my learned friend that he finished his submissions on the other day in a very precise manner, my
Yes,
lord.
anyway, these matters takes time.
Takes time, my lord. So taking a cue, I'll try to be as precise as possible, my lord.
And with your written notes, I believe you have furnished this thing, the citations of.
Yes, yes, those will get.
Violations that you have.
Yes,
I
yes.
have already.
Yes. So, my lord, at page 92 again, the last paragraph, after considering the documents, evidences and materials available on record, it appears to me the date of death of Taslimuddin Mia is last part of Ocean 1383 BS on the ground that after perusing series of deeds and khatiyans, Khatiyan bin number 319, which the defendant ought to have produced, the date of Taslimuddin Mia is last part of Ocean 1383 BS. PW5, who is the nephew of Taslimuddin Mia, being deed writer, written the date in the date that is prior to 1970, but he willfully suppressed the fact and stated in cross-examination that the date of Taslimuddin Mia is 1388 BS to save the interest of his defendant's sister and
The
nephew.
deed of conveyance, was it stated when this person died?
No. It was stated as late this year.
Okay, not.
Not the date of
he
death.
died and also.
No.
It is a conveyance.
Now, kindly appreciates, my lord, there is a distinction in the role of PW5 here. Now, PW5, when he deposed as in one capacity as the deed writer, his knowledge in respect of the contents of the deed comes from the persons who are executing and accepting that deed. Now, in respect of the date of death of Taslimuddin, who is his Pishamosai, that is his personal knowledge. So he says in his examination chief as well as cross-examination that the date of death of my Pishamosai is 1388 BS. Now,
Sometimes death may be matter of knowledge, okay.
yes, so that is matter of knowledge.
If a person during his lifetime hears about death, it may be due to knowledge.
Yes.
But if a person has died long time back and from somebody he came to know.
Yes.
If a person hears the news of his death, that is within his knowledge.
Writing a deed is basically
And
a
second thing is,
responsibility.
if a person says that, suppose a person died long time ago.
Yes.
Yes, madam.
And today I hear that
Yes.
so and so person died.
That
Today Mr. X says that he died on one date, Mr. Y says he has died on
But
one
here is the
date. That
here-
hearsay.
Yes.
Here is the case of the case where Taslimuddin is the uncle, Pishemoshai of PW5. So my lord, in my respectful submission, it cannot be hearsay, personal knowledge.
If it is
Now-
the person
now-
who likes the
now-
point writing the deed, it was his responsibility
yes,
to
sometimes it is
ascertain
a-
the facts.
Yes,
But
if it is a near relation,
Yes.
it's
It is
personal
his
knowledge.
responsibility.
And a deed writer, and deed writer,
At the
my
time
lord,
of writing the deed.
and a deed writer, to my limited knowledge, will not verify the instructions given
The
to
deed
him.
writer who is who?
Okay,
Oh.
PW1.
PW5 is the deed
Okay,
writer.
now PW5 is the deed
Deed
writer.
writer.
Yeah.
And PW5 and
He's also
He-
the
is also the uncle of.
uncle of the deceased person.
No. Deceased person is the
So,
uncle of
deceased person was
PW5.
the uncle of PW.
Pishemoshai, my lord.
Pishemoshai of the PW.
Now, going forward, my lord, that paragraph. In this way, plaintiff was, and one thing again here, my lord, the learned trial court, without any,
Sometimes you see, if you have many relatives,
Hmm.
sometimes
It's difficult
it is
to remember the date of
sometimes
death.
it is possible for you to remember the death of some of the relatives.
Yes.
had it,
Not date.
Yeah, not
At
the
least-
date.
at
no,
least
not
the
the day, he's
not
saying
the
the
day,
year,
At
it
least
is
the
not.
year. But for all the relatives, it may not be.
Yes, so here, my lord,
That might
PW5
have
did
been a
not,
mistake on his part.
PW5 did not say the date. He said the
Yeah.
year.
Yeah, that might have been a mistake.
And the learned court, my lord, in its wisdom, has disregarded it with the observation that he is trying to save his sisters and cousins.
There's a registered deed wherein he has stated that same
So,
person
my lord,
to be dead 5 years
my
back.
lord, may I,
Okay, trial
may I-
court
my lord-
did not consider the cross-examination.
my lord, may I,
Trial court considered the cross-examination.
My lord, may I
in
make-
the documents submitted in evidence.
my lord, may I make one humble submission, my lord? Humble also
Oh.
request to my learned
Yes,
friend.
okay, I know.
This relay will
Yes,
only extend the time.
You have completed.
My lord, learned friend will get time, my lord. So, since there is a shortage of time. So therefore, my lord, based on that, this was the finding of the learned court, trial court in respect of the date of death. Now pausing here for a moment, my lord. In respect of the applicability of Daya law before 1st of July 1980 to the Muslim subjects of Kuch Bihar state, there is no dispute. Whether the daughters were able to inherit a property from the deceased father under the uncodified Daya law is a matter of dispute between the parties. Now, I'll be relying on Mullah's law, my lord. I'll take this up a little later. I've just asked for the book, my lord. Now, I'll take your lordship, my lord, to the next question framed at 150, which is, I'll place it, my lord, whether the deeds on the basis of which the plaintiffs have claimed the declaration title have been proved in accordance with law. That is the second. Now, this, my lord, was the issue thereafter, my lord. So issue numbers 1, 3, 4, 5 and 6 have been taken together. Now here I will, my lord, not, my lord, take much time with regard to the deeds, because already during that part of time I have said, my lord, except deed number 2649, rest of the deeds were not executed. Their contents were not proved. So therefore,
Anyway, your learned friend cannot rely on those.
yes. So, and these were the deeds, my lord, which were relied upon by the plaintiff in their plaint case from paragraph numbers 4 onwards, 4, 5, 6, 4 to 6. This is how they, my lord, they have claimed title based on these deeds. My lord, I'll just plaint. Kindly takes up page 2 of the paper book, my lord. My lord is there, page 2. My lord is there, page 2, paragraph 4, 5, 6. 6 is a long paragraph, my lord, which goes on. Then 6, 7. Till 6, my lord. 6 ends at page 6. So these are the paragraphs, my lord, in which the plaintiffs have claimed that title.
That means you see, at that point of time, in Kuch Bihar, both Hindus and Mohammedans were governed by the old Hindu Daya
Daya Bhaga. Unless the Muslim subjects had opted to be governed by the Muslim law.
Both Hindus. and
Yes, yes, yes. And to be candid, my lord, before I was briefed in this matter, I had no knowledge about this particular
right.
aspect of law, my lord.
Yes.
There's a very interesting point of law.
Definitely. Many of us.
Yes, there's a very interesting
many of
point
us
of.
do not know this.
Yes.
Yes, there's a very interesting point of law.
Advocates who generally practice in the sub-divisional
North Bengal.
courts, lower courts at Kuch
Kuch
Bihar,
Bihar.
Yes.
they are well aware of this law.
Yes, of course.
Because they have to.
They have to,
Not
yes.
all Jalpaiguri are.
Not all general, but we who go to this
Kuch
Kuch
Bihar.
Bihar courts and
Yes, sir.
sub-divisional courts, we know this thing. This is a different case.
Right.
So
This is an exception.
this is an
But it's
exception.
not available all over India.
Yes. So it was actually a very learning experience, my lord. Now kindly comes to page 96 with regard to the second question, my lord. No, sorry, my lord, not 96. 95. Now 95, my lord, I'll here 95, my lord, with regard to issues 1, 3, 4, 5, and 6. Here, my lord, the learned trial court had discussed on the applicability of section 34 of the Specific Relief Act. And my lord, the learned first appellate court has also, my lord, discussed section 34 of the Specific Relief Act. And one of the grounds for setting aside of this judgment was that. Now, the court, my lord, did not, no substantial question of law was formulated. But again, my lord, I'll draw your lordship's kind attention to section 100, the proviso of section 100 of CPC, my lord, where question of law during hearing can be, my lord, substantial question of law if the court so feels can be formulated, my lord. So here I'll place it now, my lord. Page 95, my lord. Issues 1, 3, 4, 5, and 6. Those above mentioned 5 issues are taken together for better and convenient discussions without repeating the same thing more than one. Learned advocate of the defendants did not raise any questions regarding issue number 1 and 3 and any specific plea thereof. Thus, it can be assumed that these mentioned issues are admitted. Let's see what are 1 and 3. 1 is whether the suit is maintainable in facts, law, and present prayer and present form. 3 is whether the plaintiffs have any cause of action to file the present suit. So since I did not raise any objection there, I cannot say anything against that now.
Regarding maintainability, no question.
No. Next paragraph. Learned advocate of the defendant stated that under section 34 of the Specific Relief Act that no suit shall be entertained by the civil court if any such declarations where the plaintiff being able to seek further relief than mere declaration of title omits to do so. Therefore, the plaintiffs are unable to seek any alternative remedy except mere declaration, then the suit shall be barred by section 34 of the Specific Relief Act. In this instant case, learned advocate of the plaintiffs prayed for a declaration to the effect that the plaintiffs have right title and interest as well as possession over Schedule A property, along with an order of permanent injunction restraining the defendants from entering into the suit land and interfering with the peaceful possession of the plaintiffs and the suit land. In the suit land. Thus, it is clear that the plaintiffs did not merely pray for declaration, but alternative remedy as prayed by the plaintiffs. Regarding issue number 6, now let us see what is the issue number 6. Whether the suit is barred by law of limitation? No. Yes. Limitation, my lord, we have not taken. Regarding issue number 6, the learned advocate defendant submitted the instant suit has been filed beyond period of limitation and has stated that the cause of action took place on 11/12/1997 and the suit has been filed on 5th February 1998, but it appears to me the suit has been filed within the period of limitation. Regarding issue number 4, non-joinder of parties. My lord, I will not trouble your lordship with this because these are usual difference which is taken. Now comes to issue number 8 and 9. 8 and 9 are whether the plaintiffs are entitled to get a decree as paid for, whether other relief, if any plaintiff is entitled to get. These two at page 96. At these two issues are taken together for better and convenient discussions without repeating the same thing more than once. Now it is to decide by this learned court whether the plaintiffs are entitled to get the decree as paid for or any other relief motives thereof. Most vital issue, that is issue 2 and 7, have been decided in favor of the plaintiffs. As the date of death of late Taslimuddin Mia, this took place on last part of question 1383 BS. Thus only the male heirs are the successor of late Taslimuddin Mia would be entitled to inherit the property of the deceased father. As Kujbihari Muslims were guided by Hindu Dayabhaga law of inheritance. On the other hand, it has been established that the plaintiffs have right title and interest over the A schedule property of the plaintiff except the properties mentioned in schedule A4, A5, A and B. The reasonable doubt arises in the mind of this court that who is in the possession of the suit property, as the defendant submitted their Khutian number 319, in which it is clearly stated that the defendants are in possession of 4.07 acres of land out of 8.84 acres of plot of land which was owned and possessed by late Taslimuddin Mia. It has been decided previously that only male heirs and successors of late Taslimuddin Mia is legally entitled to inherit the property of the deceased father. Thus, the defendants have no right title interest over the suit land. For the sake of argument, now kindly my lord takes note of this. For the sake of argument, if it is assumed that the defendant number 1, Majidun Nacha Beva, was legally entitled to inherit of her deceased father, then she is entitled to got only 2.2 acres plot of land. But as per Khatian being number 319, she is in possession of 4.07 acres plot of land, which has exceeding her limit of share any by virtue of what document or other document she is holding. The property exceeding capacity is also not provided by the defendant. So the learned court cannot rely upon Khatian number 1 on the ground that the defendants could have prayed for an advocate commission to establish the fact that the defendants are in possession over the suit property. Now, my lord, I am pausing here for a while. Now, the learned court, while deciding the death of my father, relies on Khatian number 319. There is a declaration which made that Taslimuddin died during a time when Dayabhaga law was governing the Muslim subjects of Kuch Bihar. Now, the learned court, when it comes to decide on the possession, disregards this piece. And then, my lord, quite surprisingly, comes to a conclusion, though for the sake of argument, but without any basis, that the defendant number 1, as she was during her lifetime, was entitled to get only 2.2 acres plot of land. But she has shown to be in excess of possession of 4.07 acres of land. Now the Khatian is still in force. No steps have been taken by anybody to challenge the Khatian. And
The question is with regard to issues, you see, that regarding
Yes.
that inheritance aspect,
yes,
the other is the possession aspect.
yes, my lord. So if a Khatian is there in my name, prima facie, though rebuttable, prima facie, my lord, presumption of possession.
Presumption of law.
Though rebuttable, my lord.
Inherit-
And if your lordship kindly sees, my lord, in the exhibits, my lord, 319, it has been stated that inheritance, by way of inheritance, my lord, they are claiming ownership.
How much possession these plaintiffs have been able to show? This purchasers plaintiff.
Entitled deed.
No, the question regarding possession, they claim to be, they have been put into possession.
Yes,
With regard to the suit land,
suit land.
on which they prayed for injunction.
Yes,
They claim to have been put into possession.
yes, my lord. Unpartitioned suit land, but they claim declaration in respect of that. Now, my lord, the last paragraph of page 97. Now let us examine the oral evidences of witnesses. PW1 has stated that he is in possession of the portion of suit land. PW2 also stated that he is in possession of his portion of suit land. PW3 being independent witness stated that the plaintiffs are in possession of suit land. PW5 has stated that the property of late Taslamuddin one Mia was owned and possessed by his male heirs. Subsequently, after repeated questions by the learned advocate for the defendants, he said that the property of late Taslamuddin Mia was owned and possessed by his male and female legal heirs as successors of late Taslamuddin Mia. Was uncle, that is Pishamosha of PW5, and by profession he was the deed writer. So it can be clearly inferred by that PW5 is well acquainted and have good relationship with the defendants. Thus, he was stated actual fact and subsequently protected the interest of defendant number one. Now, whenever, my lord, this is, my lord, quite surprising, my lord. Whenever the independent witness PW5 stated anything in favor of the defendants, the learned court comes to a conclusion that it is only to protect the right and interest of the defendant number one and her children. And another interesting
So
point.
far, you see, defendant number 5 is concerned,
Yes.
he is not the relation of the plaintiffs.
No.
But so far the defendants are concerned, he is the relation of the defendant.
Yes. So he has knowledge, my lord, who is in possession and who is not in possession.
No, regarding the date of death
Date of that he will definitely have, my lord.
he will definitely have. And possession.
Possession, my
Third
lord.
party has also adduced
Yes,
regarding possession.
yes. So defendant number 5 says that the plaintiff and the,
Anyway, these are all factual aspects.
yes, but
Say,
just to,
Whatever it is.
my lord.
we have to consider the question of law.
Yes. So thus is stated the actual fact subsequently protected interest. Thus it is crystal clear that the defendants have no possession. My lord, how, my lord, the learned court came to that conclusion, my lord, it is not clear. But the plaintiffs are unable to provide any document or any evidence before this learned court to establish the fact that they are the owner and possessor of the property mentioned in Schedule A, such and such, except the mere statement stated in the plaint. So plaintiffs are entitled to get the decree in part as prayed for. Thus it is. Now, my
That is what you see in second appeal, there is hardly any scope to go through all evidence.
yes, there is hardly. But
Whatever is formulated and the questions of law on that.
yes, on that point, because whether the have been proved to able to prove that the second question, these on the basis of the plaintiffs have claimed the declaration of title has been proved in accordance with law. To that, my lord, my humble submission is that except deed number 2649 of 1976, which is exhibit 3, none other
The
deeds.
purchasers have exhibited their deed of purchase.
No, my lord, all kept for as X for identification.
It's already exhibited since the signatures were also exhibited.
Hold on, let us see that.
Kindly comes.
us-
Kindly comes to page number 88.
88, my lord.
Kindly note that the exhibit 4.
88.
88, 89 first, my lord.
So first, let's
80
see the
89,
exhibit.
my lord, kindly sees the
Those were initially
exhibits-
marked as marked
Now,
for-
now let us see.
exhibits of documents for X for identification, exhibit
Exhibit
X for
See,
identification,
registered sale deed, that is there.
Hmm.
That is the prior to the purchase. This is-
2649.
2649.
That is prior to purchase.
That is the-
By this plaintiff.
Only, that is the only deed which was executed by Taslimuddin, who is now dead.
Okay, now thereafter, these plaintiffs came to picture when?
Subsequently, from 1978, 80, 81, 82, 80,
All these
80,
deeds.
all these deeds.
Now 78 means which? This exhibit 4 is 79.
Exhibit 4 is 70, exhibit 4 is 79.
79. Okay,
79.
collectively. And then exhibit 5 is 80.
Exhibit
80.
5 is 80.
Not the deed, my lord, the signatures.
But the-
That will be considered whether the
Yes.
deed or the signature.
once the signatures, it was marked as X for identification or X by 1 for identification, because the signatures were not exhibited at that point of time. Once the signatures get exhibited, the entire document gets exhibited. It cannot be said that only the signatures get exhibited
My lord-
without the document.
Okay, these decisions were relied upon anyway, you.
Yes,
Like
and
in
with
your
regard,
written notes.
with regard to decision, my lord, AIR 1981 Calcutta 49 is the decision which my learned friend had placed on the earlier occasion regarding the applicability of Dayabhaga, pre-codification Dayabhaga law on the Muslim subjects of Kuch Bihar state.
That is admitted.
It is admitted, there is no question about that. The averment which they had taken, and that in this judgment, it has been stated that the daughters do not inherit, which my lord has been pleased to see that in the entire judgment, there is no such a whisper of thing. It says, it has clarified that before this date, this was the position of law. After this date, this was the position of law. This was the date when the notification has come for the assimilation of law.
Well,
This is what it has been clarified.
Well, to find the names of the parties, and from there it would be static that whether the daughter was.
So this is it. No, names of the parties where in that judgment.
That's it.
In that judgment, the names of the parties, these parties were not there.
No.
Very well.
Mentioned there.
Then my lord, I'll place that judgment. My lord has a copy of the judgment, or I'll give another copy.
Because you'll give this compilations.
Yes,
You'll have to do it in-
just for the fact of it, my lord. I'll come to second page, my lord. I'll place it. From paragraph 1. This rule is directed against order number 20 dated 28/6/1978 made in title suit number so and so by Munsif so and so and the district of Kuch Bihar. By the said order, the learned Munsif deposed of applications made by 3 sets of persons claiming to be substituted in place of one Anima Khatun, widow of late Amina Khatun, late of Ishakuddin, who was the plaintiff, who as the plaintiff brought the said suit. Admittedly, the said Amina Khatun died issueless on February 26, 1978. There is no dispute between the parties regarding the legal position that if said Amina Khatun at the time of her death were governed by Mohammedan law of inheritance, the present petitioners would have a claim to be substituted in her place as preferential heirs of said Amina Khatun according to the provisions of Mohammedan law of inheritance. It is further admitted legal position that if said Amina Khatun at the time of her death were governed by Dayabaga School of Hindu law in the matter of succession, the opposite party number 3, Yusufuddin, would have the right to be substituted in place of Amina Khatun. Another set of persons, namely Majidun Matijanessa and Amina, claim to be substituted as heirs of the said Amina Khatun. But in view of the fact that under Mohammedan law of inheritance, the present petitioners are the preferential heirs of the said Amina Khatun, and under Dayabaga law of Hindu law, opposite party number 3 is the preferential heir, there is no substance in the claim of the claim preferred by Majidunasa and Amina. In view of what is stated above, the short point that arises for determination is the present rule. In the present rule is whether the plaintiff Amina Khatun was governed on February 26, 1978, which was the date of her death, by the Mohammedan law or inheritance or by the Dayabaga School of Hindu law. When question came up for hearing, the learned lawyer appearing for the petitioners pointed out that even though the fate of the rule depended on the answer to the aforesaid question, the decision to this court would take in the matter would have a far-reaching effect inasmuch as the said question would fall for determination in quite a good number of cases. Accordingly, on being requested by this court, the learned advocate general rendered all possible assistance. Kuch Bihar was previously a princely state of India, came to be merged into and constituted a district of West Bengal under the States Merger West Bengal Order 1949 with effect from 1st January 1950. The merger aforesaid, however, did not by itself bring about any change in the laws to which Kuch Bihar was subject before the aforesaid merger. Accordingly, even after merger was brought about by the said order of 1949, the laws which applied to Kuch Bihar before the aforesaid merger continued in their application even thereafter. This being the legal position, it was found necessary to assimilate the laws which were in force in Kuch Bihar previously to the laws in force of West Bengal. This necessitated passing of the Kuch Bihar Assimilation of Laws Act 1950, which was an act of parliament. As the subject of this legislation covers matters contained in both union and concurrent lists, effectual assimilation of law would be brought about by simultaneous legislation made by both by the central and the state West Bengal. That being so, the West Bengal legislature also passed the Kuch Bihar Assimilation of State Laws Act 1950. Both the aforesaid Act, one passed by the central legislature and the other by the state legislature, simultaneously came into force on 1st January 1951. Before the aforesaid merger, Kuch Bihar and before it became as a result of such merger, one of the district of West Bengal, the Mohammedan subjects of Kuch Bihar state were being governed by the Hindu law in matters of inheritance. As many Mohammedans desired that they should be governed by the Mohammedan law, an act called the Mohammedan Inheritance Act, Act 2 of 1897 was enacted. That came into force on April 1, 1897. According to the provisions of the said act, any Mohammedan subject of Kuch Bihar state designed to be governed by the Mohammedan law would be required to make a declaration in the matter provided in that act. that he desired to be governed by the Mohammedan law in matters of inheritance. On such a declaration being made in the manner prescribed, the declarant would therefore thenceforth continue to be governed by the Mohammedan law of inheritance and would cease to be governed by the Hindu law of inheritance, notwithstanding any customs or to the contrary. In the present case, there was no such declaration made under the provisions of the State Mohammedan Inheritance Act, and Amina Khatun, who was subject of the state of Kuch Bihar or estate left by, did not come to be governed by the Mohammedan law of inheritance. The learned lawyer appearing in support of the rule contended on the strength of provisions of Section 3(2) of Kuch Bihar assimilation of State Law Act 1950, that all laws which immediately before January 1st, 1951, which was the date on which the Act came into force, did not extend to or were in force of Kuch Bihar, should as from that date they extend to, or as the case may be, come into force in Kuch Bihar, and all laws immediately before that day which were in force in Kuch Bihar but not in the rest of West Bengal should on that day cease to be in force, except as respect things done and omitted to be done on that date. If the statute stopped there, the obvious result would have been that Mohammedan Inheritance Act would stop applying to Mohammedan subjects of Kuch Bihar from after 1st January 1951, and instead the Muslim Personal Law Shariat Application Act 1937 would have applied to the Mohammedan subjects of Kuch Bihar. But subsection 2 of section 3 of Kuch Bihar Assimilation of State Act 1950 provides as follows. Notwithstanding anything contained in subsection 1, the Muslim Personal Law Shariat Application Act 1937 such shall come into force in Kuch Bihar only on such date as the state government by notification in the official gazette occurred. And Kuch Bihar Act 2 of 1897, known as Mohammedan Inheritance Act 1897, shall continue to be in force in Kuch Bihar until that day, and shall on that date cease to be in force except as respect things done or omitted to be done before that date. The result is that despite the provisions of subsection 1 of section 3 of Kuch Bihar Assimilation of Laws Act 1950, the Muslim Personal Law Shariat Application Act 1937 would not apply to the Mohammedan subjects of Kuch Bihar and district till the state government by notification in the official gazette appoints a date on and from which the Muslim Personal Law Shariat Application Act 1937 shall come into force in Kuch Bihar. And the learned Advocate General brought to the notice of this court that such a notification as the one contemplated by subsection 2 of section 3 of the Kuch Bihar Assimilation of State Laws Act 1950 was published only recently. That was the notification number such and such date, 27 June 1980, whereby the state appointed 1st day of July 1980 as the date on which Muslim Personal Law Shariat Application Act 1937 would come into force in Kuch Bihar. In the case before us, the succession opened on February 26, 1978, and the question of substitution place of said Amina Khatun would be determined in accordance with the law which was then in force. There can be no doubt that on February 26, 1978, the Muslim Personal Law Shariat Application Act 1937 had no application to Mohammedan subjects of the district of Kuch Bihar. Under section 2 of Muslim Personal Law Shariat Application 1937, notwithstanding any custom or usage to the contrary in all questions regarding intestate succession and certain other matters stated therein, rule of decisions in cases where the parties were Muslims should be the Muslim Personal Shariat Application in 1937. The learned lawyer appearing in support of the rule further contended that on the date of death of said Amina Khatun, that is 26 February 1970, the Mohammedan law would have applied to the present case and the question of substitution would have been determined according to the law. This is so according to the learned lawyer, section 37(1) of the Bengal Agra and Assam Civil Codes Act 1887 so provides. Section 37(1) runs as follows. I am not troubling the Lordship with this. Lordship will kindly, yes, will come to section 9, paragraph 9. Further, it is contended on behalf of the petitioner that when by reason of provisions of section 3(2) of the Kuch Bihar Assimilation of State Law Act 1950, all laws which were in force in the state of West Bengal did, as from 1st January 1951, extend to, or as the case may be, come into force in Kuch Bihar. The Bengal Agra Assam Civil Codes Act 1887 should have applied to Kuch Bihar from 1st January 1951, and under section 37 thereof of the Muslim law in cases where parties are Mohammedans should form the rule of decision. I find it difficult to accept this contention, even if it is considered that section 37 of the Bengal Agra and Assam Civil Codes Act did apply to Kuch Bihar by reason of the state Mohammedan Inheritance Act. The Mohammedans of the state of Kuch Bihar, as it then was before the state merger, was used to be governed by Hindu law in matters of inheritance, could adopt Mohammedan law of inheritance only by a declaration made under the provisions of that act The provisions of section 37 of the Bengal, Agra and Assam Civil Codes Act 1887 would have no application to Mohammedan subjects of erstwhile state of Kuch Bihar or of the district of Kuch Bihar after the merger, as the provisions of section 37, 37, section 37, 1 of the Bengal, Agra and Assam Civil Codes Act 1887 would apply only in cases whereby any legislature enactment the law contained in that section was altered and abolished. The law that where the parties are Mohammedans, the Mohammedan law shall form the rule of decision shall not apply to the present case, inasmuch as the Mohammedans of Kuch Bihar were governed by Hindu law. In the circumstances, I cannot hold that was rightly substituted in place of submission. So here, my lord, the question was, which was clarified by the Honorable Court, was the application of that law prior to assimilation, post assimilation, the date when it has been done. Now, having said that, now our primary contention was and still is that Taslimuddin Mia died on 1388 BS, which is 1981 according to the English Gregorian calendar, and which is after the date of assimilation, that notification which said that the Muslim subjects of Kuch Bihar will be cease to be governed by the Daya Bhaga law from 1st of July 1980.
So he died after 1980,
Our contention is
1985.
1981. My calculation of 1388 BS is 1981 or 82, 81, but after 1980, July 1980. Now, just for my lord, section 34, I'll take your lordship once to the order passed by the first appellate court once, which is at page 115. My lord, kindly comes to 117, my lord. Points for consideration. The only point for discussion in appeal is whether the Leonard trial civil judge Junior Division Mathabanga Kuch Bihar committed any error in decreeing the suit on contest and thereby causing any miscarriage of justice, or whether it appreciated the evidence, either oral or documentary, properly to come to his findings. Fact of the case is that Taslimuddin Mia was recorded tenant in respect of entire land of RS Khotian number 155 and 264 and possessed the same under his personal cultivation. During lifetime, he transferred 38 decimals of land of RS Hall plot number 4650 to the plaintiff number 9 with a registered sale date number 2649 dated 25th June 1976 and delivered possession. Taslimuddin Mia was Kuch Bihar Muslim and was guided by Hindu Daya Bhaga law in the matter of inheritance and succession. He died in the month of last part of Ushin 1982, leaving behind his three sons, namely Ayub Ali Mia, Abdul Hamid Mia, and Abdul Aziz Mia, and one daughter, Majudunisa Beva. As Taslimuddin was guided by Daya Bhaga law, so his three sons inherited all the properties left by their father, Taslimuddin Mia, and possesses the same under personal cultivation. Defendant number 1 got married during lifetime of Taslimuddin and after marriage started residing with her husband along with two sons, and that is defendant number 2 and 3. The defendants never owned and possessed any portion of land, suit land at any point of time, nor they have any possession of any portion of suit land till date. On 7 September 1981, Abdul Hamid Mia, by registered sale deed being number 478347, this is how, my lord, the chain of title has been discussed. Now, my lord, I will not trouble your lordship with all this. Kindly comes to page 119.
This is the factual discussion.
This is the factual discussion.
119.
119, second paragraph, the last paragraph. By filing written statement, defendants deny the material allegation leveled against him. It is also stated that the suit is non-maintainable in law and facts and has no cause of action. It is also stated that suit is barred by limitation and under section 34 of the specific relief act. The specific case, so here, my lord, the point of section 34 of specific relief act was taken up. Now, my lord kindly comes to page 120. My lord is there. The second paragraph. Upon pleadings of both the parties, following issues are framed by the latter trial court. The issues were given. Now, the next paragraph. To prove the case, one Abdul Majid deposed as PW1, one Muhammad Abbas Ali Mia deposed as PW2, one Akbar Ali Mia deposed as PW3, one Abdul Jabbar deposed as PW4, one Abdul Kader Basunia deposes PW5. Plaintiffs are relied on some documentary evidences which are marked as Exhibit 1 RS Kotian, Exhibit 2 RS Kotian, 319, Exhibit 3 sale deed, number 2649, Exhibit 4 to Exhibit 17, signatures of different witnesses on different deeds. The deed numbers are mentioned. Next page, my lord. On the other hand, defendants Muhammad Makbul Mia deposits DW1, however, no documents have been relied by the defendants. On perusal of the plaint, I find that one Taslimuddin Mia was the recorded tenant in respect of 16 Anna shares of RS Katian number 155 and 264, but nowhere in the plaint quantum of share has been mentioned. It further appears that schedule of the plaint has not been properly described. From the plaint, I find that sons of Taslimuddin Mia has transferred properties to different plaintiffs with a registered sale deed, but those registers have not been marked exhibit in the instant case. From the plaint, I find some properties were transferred to plaintiff number 9, but in the cost title of the plaint, I find no such plaintiff number 9. I find no such whisper that plaintiff number 9 is one of the plaintiffs to the suit. Here, my lord, I will be candidly submitting that it was a typographical mistake which was taken into record by the learned trial court while passing the judgment. It has to be plaintiff number 6.
No, in the operative portion of the decree, was the name of the plaintiff correctly mentioned? In the
Decree kothay go?
In the original decree,
Yes.
on its trial court, it was correctly.
It was correctly after the amendment was taken into
Yes.
consideration.
It was correctly mentioned by the land trial court. But the proof of happened before the landed first appeal.
ডিগ্রিটা দিয়েছো এখানে?
No,
First
the
appeal.
amendment was carried out.
কোথায়?
The amendment was carried out before the trial.
Trial court.
The
That was
decree-
taken into consideration, landed trial court, or taking into consideration.
The decree was passed in accordance with the correction amended.
Yes,
Well, I cannot find the decree here, man.
yes. Decree.
কোথায় গো? পেজ নাম্বারটা বলো তো।
What group? Page number. আচ্ছা আচ্ছা decree.
না থাকবে নাহলে তো ডিফেক্টিভ হয়ে যাবে।
থাকবে। Judgment report. Page number 101.
101. আচ্ছা।
Oh, this should coming for this for 101.
আসলে তার আগে টাইটেল এপ্রিলের এটা আছে না, আমি ওটা ভেবে- I just
101,
lost it.
102, 103, 104.
No, I missed it because my lord, page 100 is the, it says the additional district judges court, so I presume that
Yes,
101 is the decree, my lord.
With the decree, everything is reflected properly.
Yes.
Yes. And decree, my lord, everything is there.
Everything is.
So that, my lord,
Only in the body of the judgment, there is some mistake.
no, that has been
Body
corrected.
of the plaint. there
Plaint,
was
my
mistake,
lord.
it
Body
was
of the
corrected.
plaint, there was a
Mistake, it was corrected by an amendment.
And in the body, and in the decree itself, there is no.
There is no there. But the landed first appellate court failed to consider.
To fail to consider that. That I'll also exceed.
So this is the question. Now, which deeds were not marked exhibit as per the appellate court?
My lord, deed numbers kindly comes to page 120.
121?
Yes,
120? Yes.
120.
121, in page number 121, the landed first appellate court was of the view that the registers needed to be marked. Those were the original deeds.
Deeds.
The registers need not be marked. It was only in case of certified copies.
I find that something. By different, but those registers have not been marked.
Registers need not be marked on this.
Register-
Original deeds. Because the registers have to be marked only when certified copies of the
Certified
deeds are produced.
Yes, okay.
These are the original. These are
Yes,
already on
from
the
the place, some properties were transferred to plaintiff number 9. Oh, that is. not-
9
Anyway,
9 is basically 6.
no mentioning on the plate existence of schedule.
Yes, that my lord will be 6. Then
9
my
is
lord,
6, 10 is 7.
then the my lord,
Now
next,
the question is, this is the observation that registers are not marked.
Registers are not necessary to be marked. These are original deeds. Registers
Documents
are
have not been
only
proved. Our case-
certified copies.
our case is that documents have not been proved.
Had it not been original deeds, then the registers would have been called for from the registry office.
Next,
Then
next-
those registers were
next, my lord, next paragraph.
volumes.
At page 121. Further, plaintiffs have admitted that names of defendants have been recorded in LR Kotian number 319. But plaintiffs did not pray for any consequential relief to that effect. as plaintiff did not pray for any consequential relief, so instant suit is hit under section 34 of the specific relief act. I have gone through the impugned judgment passed by the learned civil judge, Junior Division, Mathavanga. After going through the same, I find that learned court below has failed to appreciate the plaint of the suit as well as true possession of land, and as such came to the wrong conclusion. Therefore, I am of the opinion to set aside the impugned judgment. As a result, appeal fails, such and such, ordered. that the- Fails. Oh, succeed, sorry, sorry. Ordered that the title appeal being number 20 or 15 be the same is allowed on contest but without cost. The,
So out of contentions is this regarding the date of death, which as per the PW5.
yes,
The second is this, all documents were not proved.
not proved in respect of the two substantial questions which have been formulated. Now, the first question, my lord, I will kindly reformulate it.
And one additional question.
Additional of section 34, my lord.
Yes, additional question has to be there.
Yes, that my lord can, my lord, under, I know lordship knows that under
Under
section 100, 100, my lord, can. Section 100. Yes, subsection, proviso to subsection 5, provided nothing in the subsection shall be deemed to take away or abridge the power of the court to hear for reasons to be recorded the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. So my lord can. So these are my humble submission. 100 subsection 5, proviso to subsection 5.
First proviso.
Active over. Active. My lord, now here, just 5 minutes in respect to one academic, my lord, with respect to whether in a Dayabhaga. Now, my specific case is that I will not be governed by the Dayabhaga law because my father had died subsequent to 1980, July 1980. And there was also no issue framed whether I will be guided by that or not. This is a different question. My lord, I'll just rely on this Mulla's 21st edition of Mulla on Hindu law, where my lord, yes, chapter 3, general principles of inheritance, law prior to Hindu Succession Act. Chapter 5, my lord. I'll just also give a copy of that. Here it says, law prior to Hindu Succession Act 1956. Female heirs, Bengal school. According to the Bengal school, the only females recognized as heirs in that school to a male are the widow, the daughter, the mother, the father's mother, and the father's mother. So prior to the Succession Act of 1956, prior to the codification, the daughter was,
Limited right.
it
Some
is,
limited rights.
yes, but she had a right in the property.
The nature of right is.
No, because my lord kindly appreciate.
Because this is section 40 of the Hindu Succession Act. The absolute right devolves upon this
Daughter.
woman.
Yes.
Section 40.
And prior to the codification of 1956, my lord, in Bengal under Dayabhaga, my lord, the daughter was eligible to inherit the property, my lord. And because, my lord, the judgment which your lordship has been pleased to see, that has only clarified applicability of law at that particular point of time.
Question here, you see, whatever is the case of the plaintiff and the defendant, the court has to proceed on that basis.
Yes.
Whatever is your case, if your case is, he is governed by this particular law, your
Yes.
case is, you are not governed by
No,
that
no.
law.
My case is prior to 1st July 1980, I was
Yes.
governed.
That is.
Post
your-
that I am not.
That is your case. So whatever your case, the court has to consider
Yes,
those
madam.
evidence.
He has to be either in.
Whatever is your case, the court has to
Yes.
proceed on that.
He has to be
But
either of the.
Considering the evidence of the.
No, I'm just, my lord, just for the just an academic discussion, my lord. I had
Even
made it clear.
Limited rights existed.
Yes, and he cannot say it in two votes at the same time. He cannot say that I was born after 1980. That is why I am not entitled. I am entitled to a share, and I also claim on the other hand.
No, no,
that
no.
even if
I am.
born before-
No, 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 no,
before
no, no, no.
1980,
no.
I have a share in the property.
Maybe,
tax.
my lord, I am
That
not.
cannot be both.
Maybe
Anyway, there are.
No, no,
three
my lord.
parts.
Maybe I was not able to, my lord, make myself very clear. That was just for a
Yes, yes.
academic.
Because whatever is your case.
Yes, I
that-
cannot, my lord, sail on two boats.
No, no.
Yes.
Definitely, whatever
At the
is the
same time.
case.
Yes,
The
that-
court cannot make out a case.
Yes,
Yes.
that if the date of death is this, I will be governed by this. If not, then there also I have a right. That has never been my
There's
case.
no scope for the court to make out a case.
No, no, my lord, that has never been my case. My case was that I am date of death is this, and this is the law is applicable. My lord.
Now,
The-
if the date of death is proved to be before 1980, then he is not.
No, that is one aspect. Okay, now let us come to the issues where the formal question is formulated once again.
The was promulgated by this court.
Yes, so number one has to be, in addition to number one,
Yes.
okay,
Whether the
three has to be formulated, another.
whether
Yes,
the
three.
defendants were governed by, whether the predecessor of the defendants was governed by.
Yeah,
master
one has to be
the-
reformulated.
Yes, whether the defendant number one was governed by the
But it should
Mohammedan,
be the predecessor of this is the father of the defendant.
whether the predecessor of, no,
Father
whether
of the
the
defendant
defendant number one.
Defendant
original
number one.
defendant number one.
Yes.
Because the inheritance would start only upon the date of the father of the
Okay,
defendant.
that is why I'm saying that whether the original defendant number
Number one. Yes, my lord.
see, original defendant number one was governed by the Mohammedan law of inheritance or the Ibadah School.
Yes.
I think that should be
dependent upon the date of death.
original defendant number one. What is the name?
Majitun Nisa.
Majitun Nisa Bewa.
That is the original defendant number one.
Yes.
The suit was in the year 1980,
1998.
1998.
98. So the original defendant was that. So
Yes.
that question has to be formulated.
Yes. And my lord, my humble prayer is that another issue, substantial question with regard to applicability of section 34.
That I already I will refer to, because my contention is that section 34 is applicable only when a declaration of title is sought other than any other consequential.
So
The learned trial court specifically in its order stated that I have paid for the consequential relief of injunction.
so therefore, my lord,
When
both
the
both of us,
consequential relief of injunction.
both of us will
Whether
be
the
addressing.
section 34 is applicable in.
Yes.
Yes, so both of us, I have addressed your lordship on this. My learned friend will be giving a reply on this.
Yes.
So jointly humble prayer is that another substantial question of law, if possible, may
Yes, I
Wait
got an order.
tomorrow, my lord, I'll give my written also.
Yes. Learned advocates,
I give
parties
the
are
written
present. Yes, your name please.
Kunaljit Bhattacharya.
Mr. Kunaljit Bhattacharya, learned advocate for the respondents, all the respondents,
All.
submits. You have concluded your submission?
Yes, I've concluded.
Has concluded his submissions. The matter will be fixed on 23/12/2025 at 4 p.m.
23rd.
2030.
Tomorrow.
23rd. I think in the chota.
Tomorrow at what time shall I give? Anyway, the 2 p.m.
No, my
Try to
learned,
conclude it within a short time.
Yes.
he has to catch a train.
I have, catch it.
So I'm keeping it at 2 p.m. 2 p.m. For Mr. Rahman to give the reply. And for both learned advocates to file the written notes of arguments.
And including that.
And the
Including the
judges,
relevant judgments, compilation. Upon hearing the learned advocates, considering the facts of the case and the order passed by the Honorable Division Bench on 12/9/2022, this court is of the view that in terms of proviso to section 100 of CBC, two
It's a
more,
100 subsection 5 of.
yes, two more questions of laws be formulated. Number 3, whether the original defendant number 1, what is his name?
Majitun Nisa Bewa.
Yes,
Majitan is Bewa.
Majitanasha Bewa,
Majitan is Bewa.
Majitanasha Bewa,
Now it's page number 2 of the paper book.
One.
One of the paper.
MAJITANNECHA.
one of the paper, okay,
Page number 1.
Page 1 of the paper book, my lord. Can you see?
List of defendants. First one.
okay. Maji, Majitannecha, Bewa. Majitannecha, BEWA was governed by the Mohammedan law of inheritance or Dayabhaga school of Hindu law at the time of the death of the father
Of her father.
of his father,
Of her father.
of her father,
Of her father. Taslimuddin.
Taslimuddin Mian. Yes, 4. Whether section 34 of the specific relief act is applicable in this case. So tomorrow come at 2 p.m.
And, section 34. Tomorrow. No,
They have into
section 34 also specific.
Yes, yes, I've included that.
include.
So please submit all your written
Yes,
notes,
yes,
judgments tomorrow.
Tomorrow, yes, madam. Grateful.
Grateful.
To get ঠিক করে রেখে। রেখে দিন আর বাকি যে হ্যাঁ ওটা ফিক্স আছে তাহলে ওটা কাগজ ফিক্স ম্যাটারটা ফাইলিং ঠিক করে রাখো। Yes, 4 p.m. fixed matter.
Yes, I'm for that.
Yes.
Yeah, Lordship.
You are the claimant appellant?
Yes, Lordship.
Yes, what is the ground?
So grounds are 4 grounds are there, Lordship. First of all, medical expenses calculated 6,50,200 instead and in place of 6,80,200. So, Lordship, kindly see the page number 34, para number 5 of my paper book.
Page?
34, para number 5.
Error number 5. Yes.
And page number 30 of my paper book. Page number 30, from there it's found that original medical expenses is 6,80,200. But at the time of calculation, learned tribunal assessed medical expenses as 6,50,200.
Oh, it should be 6,80,000.
80,200. That is the first one.
Yes.
Now, Rashid, point number 2, learned tribunal applied the multiply 16 instead and in place of 18. Rashid, kindly come to the page number 33, para number 4 and 6. Para number 4, as I have mentioned earlier, the injured was 16 years, 7 months old. 16 years, 7 months, 22 days old. So, as per multiply 15
So
to
it should be
18. It should be 18, Lordship.
Yes.
Then in the same page, Lordship, para number 3, 1/3 has been deducted. Lordship, which is an injury case. So 1/3, deduction of 1/3 has not been applied there.
1/3 should be deducted.
Huh?
No, 1/3 is not required to be deducted.
Not deducted. And number 4 is
No,
only,
but is it any disablement is there?
yes, disablement is there.
So what is the percentage of disablement?
50%.
Yes,
50%. That has been calculated by the tribunal.
so
And-
percentage of disablement is there.
Yes.
So regarding 18, from which schedule do you get that? That multiplicand,
So from,
which schedule? No, multiplicand theory, from which schedule?
which schedule?
Yes.
It was taken now. The schedule attached to the MBI.
Actually,
Prior to,
Yes.
schedule attached to the
it will be.
Yes, there,
And-
the 10th schedule.
10 schedule.
But I don't find it here. No, in the book it is stated that second schedule is omitted.
After amendment.
Correct.
So now second schedule is applied or just on the basis of pronunciation?
That is
This
not,
multiplicand theory
yes.
on basis of what? Earlier it was on the basis
On
of
the
second
schedule. On the basis of schedule, it is correct. Since the deceased was 18 years old,
No, question is, accident took place when?
2016.
2016.
2016, this schedule was there.
Yes,
Okay. This schedule was there in,
2016.
2016.
now regarding medical expenses, it is the matter of.
30,000 calculation, matter of
So
calculation.
regarding the 10th schedule on which the court proceeded, second schedule,
Second schedule.
on which the court proceeded, it was 16, that
16.
is correct,
That is correct.
if that is followed.
If there is,
Now the question here is regarding the calculation, that is 6,80,000,
that is on record.
6,80,200 instead of 6,50,200.
Lots.
6,80,200. Now, this is multiplier should be 16 and the other is 1/3 is deducted on what basis? What is the deduction of 1/3?
I don't know. Para number 3 of page number 33 of paper book.
Page 33.
Yes, of.
Now you see, the learned trial court has discussed that in view of 5B of second schedule, the sum of compensation is quantified so and so. That is how the compensation is quantified. Okay. See, 50% disablement on the income. So regarding income, there is.
No, there is no issue.
Okay, so regarding 50% of the disablement, 50% of the yearly income.
Yearly income.
Okay, so 50% of the yearly income plus the multiplier theory.
What was your?
Okay, so you see, if the second schedule is to be followed, then 50% of 48,000 into the multiplier theory, that is correct. The learned judge has followed that, this thing, this second schedule. But now this second schedule is not there.
Not there. After amendment of 164.
Yes, but now whatever was prior to this 2016. If the accident took place prior to 2016.
Then that schedule has to go.
Now whatever is to be followed, this multiplication theory as per
Pronouncement.
Shetty.
Yes.
Now you see, except this, this interest, that is 3 lakh, 6 lakh, this 80,000, the others, you see, there is no scope. There is no 1/3 deduction. Why do you get this 1/3 deduction? Which page?
Lordship, as a total monthly yearly income comes 72,000. Page number 33.
Okay.
My yearly income comes 72,000 at the rate of 6,000 per month. And the third para, in the case of nature, the claim of the injured is liable to be reduced by 1/3. Therefore, the sum of rupees 24,000 being the 1/3 of the annual earning of the injured is liable to be reduced.
The tribunal used his discretion considering the nature of the injury.
Is there any scope under the second schedule regarding that 1/3?
No. But so from the judgment, it appears that in the case of this nature of claim of injured, that is the.
If see, second schedule is to be followed, let it be followed in entirety.
Plus.
So if second schedule is followed, then 50%, you see 50%, whatever is there.
Yes.
So it should be 48,000 or 72,000. That is the question. So you see, case of victim deceased, definitely that 1/3 deduction.
In injury case, there is no scope in the schedule.
No, do you have anything, this thing, in the second schedule that there will be 1/3 deduction?
No. In case of injury, there is probably no.
In case of injury, so that 50% of 72,000.
Loss. Into 60.
So you give the calculation, what it would be?
Lordship?
Give the calculation, 50% of 72,000 into 60. Only
I
this
made one
much.
conclusion, but I have concluded it with 9,000 per income. So give me
No, how much you have taken?
at 6,000. But in the calculation, I have taken 9,000.
No. Question is yearly income.
Yearly income 72,000.
Yes, 50% of 72,000
Yes.
into 16
Yes.
plus the 30,000 on account of pain and suffering.
Loss.
No, 30,000 হচ্ছে medical income.
No,
That has been
that
reduced to-
instead of you said 5 lakh, 6,50,000, you said 6,80,000.
8,020.
30,000 will be increased.
Lordship, I have another point. That is the pain and suffering only granted by pain and suffering only 5,000 granted by the tribunal.
Everybody is
Even-
there. Well, the 5,000, how much for?
Only 5,000.
Pain and suffering.
Pain and suffering. That is for.
Anyway, let us consider only this aspect.
Loss.
Page number 34,
Page 33.
page 34, second last para.
Yes, pain and suffering, I'm not going into all these things. I'm
Is
going into
entitled to
that
the-
issue, that 1/3.
1/3. Loss.
Yes, record an order. Learned advocates for the appellant's claimant and learned advocate for respondent number 1.
Lordship, one indulgence.
Yes.
May I give to Punashetty judgment?
Yes.
Para number 40/22, the learned constitutional bench holds 15 to 25, 18.
15?
15 to 8, age 15 to 25. Multiplies
Anyway, you
18.
see, I'm not going into the chronicity because second schedule is followed. I'm strictly going by the trial judges, you see, guide, the line. So let us follow that second schedule, what the trial judge has decided. And then take that 72,000. Yes, learned advocate for the appellate claimant and learned advocate for the Sriram General Insurance Company Limited are present, are learned advocates. The appellants were claimants before, the appellant was the claimant before the learned trial and is agreed by the judgment and award dated.
What date? 17th October 2020.
Yes, 17th October 2023, passed by learned additional district judge, first court, Jalpaiguri, in MSC case number 51 of 2017. Stop. The next para, the ground of challenge in this appeal is the learned trial judge, upon considering the income of the appellant claimant, has deducted 1/3 on account, which is not provided under the second schedule and also not provided in any of the judicial decisions. Stop. Learned advocate further submits that the total income incurred on account of total expenditure incurred for the treatment of the claimant is rupees 6,80,200, but the learned trial judge by mistake recorded it as 6,50,200. Learned advocate also submits that the amount awarded on account of pain and sufferings is also very meager. Learned advocate for the opposite respondent number 1, insurance company disputes the submission made by the learned advocate for the appellate. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that the learned trial judge has proceeded to decide the claim case on the basis of second schedule to the Motor Vehicles Act. Motor Vehicles Act 1988. So it was deleted in which year?
It came into effect in 2022.
So it existed. On when the case was instituted, the second schedule under the Motor Vehicles Act 1988 was in force. Thus, the learned trial judge did not err in proceeding to decide the case on the basis of the second schedule. Stop. However, as there is no provision in the second schedule to deduct 1/3 in the case of partial disablement or injury, the learned trial judge erred in deducting 1/3 from the total yearly income of the claimant appellant. Stop. Further, the learned trial judge erred in calculating the total expenditure on account of medical expenses, which is 6,80,000 and not 6,50,200. Stop. With regard to the amount awarded on account of pain and sufferings, this court does not think it fit and proper to interfere in such decision. Thus, the annual income of the claimant appellant is considered to be rupees 72,000. As it is the case of 50% disablement, it shall come to 50% into 50% of 72,000 into 60. How much it comes? Which comes to?
Sure.
No, it has,
5 lakh.
no. Have you proceeded with this 50% of 72,000? How much?
5 lakhs.
Oh, one is 36,000.
36,000.
36,000 into 16. How much?
16.
5,76,000.
5,76,000. Thus the total compensation, 5,76,000 plus 30,000.
plus 6,80,000 total.
Yes,
6,80,000.
No, already that was taken, 30,000 will be the enhancement.
Now, 30,000 will be enhancement, but total, after calculating the total and deducted the amount that has been deposited to the.
5,76,000 plus 30,000.
So, Lordship, 5,76,000 plus 6,82,000 and pain and sufferings added, then deducted the amount that has been.
I'm
submitted
just
in the
adding the extra. I'm
Extra,
just
yes.
adding the extra.
Okay,
No, whatever is calculated is there, whatever is the deficit.
okay.
Rupees 30,000, which is not awarded on accounts of medical expenses, is awarded, and the total comes to 6,00,000. 6,000. Stop. As courts have power to grant just and reasonable compensation, this court is of the view that rupees 6,00,000 is just and reasonable compensation. Stop. Thus, the claimant's appellants is entitled to 6,00,000 from the respondent number 1, Sriram General Insurance Company Limited. The respondent number 1, Sriram General Insurance Company Limited, shall deposit the said sum along with interest from the date of filing till today, excluding the
Amount
sum which is already deposited in terms of the order of the learned tribunal. Such deposit shall be made within 5 weeks from the date of communication of this order. Before the registrar, Circuit Bench Jalpaiguri. So total 6,00,000 you are getting. That's it. So I'll take it tomorrow. So it is appearing in the list. Anyway, mention tomorrow, okay? I'll take it up. Yes. What is a motor accident claim?
It's a review filed by the bank. At the same time, the auction purchase is questioning the execution proceedings before the the last option we had mentioned, we had filed the.
Okay, tomorrow, day after tomorrow, we'll definitely take it up, okay?
Tomorrow is the time,
No, but you serve notice, bring the other side tomorrow.
we have already, we are not, the main follower.
No,
However, the auction purchase is questioning.
you're the bank authority.
We are the bank. Auction number 80.
No, auction is proceeding where?
Already bank had sold the property in auction.
Yes.
But however, the borrower challenged the auction notice, and behind our back, there the auction was stayed in the civil tribunal. That order was sent to the GRT. The GRT directed since the auction has been sold, directed the bank to return the money to the auction purchaser. But
That will take some time, so.
But our
So,
point is that.
question is you better try it before the next circuit, because you see, it's not on one line order that I will stay the proceedings.
That since our review is pending, twice there was direction upon the borrower by the opposition.
No, now the question is, as the review is pending, the further proceedings shall not be done.
Or to abide by the result of review.
No, you see, that much I can do, as because the review proceeding is pending, let other auction proceedings be stayed.
Yes, that was,
That means you do not proceed with the auction.
the auction would not direct the bank to refund the auction amount.
Auction amount is returned.
Direction of given to us to return the auction amount.
Okay, that can be stayed for a few days.
Yes, that will be well.
So you will not be prejudiced, because if you don't return, there will be execution proceedings.
They have initiated the execution.
That, so some limited protection will be given, thereafter the matter will come before the next circuit.
My lord, may I mention one matter, item number 75, may it be fixed on next circuit, my lord.
So I shall do that tomorrow, okay, mention tomorrow, I'll do that tomorrow.
Okay, great.
So it is appearing in the list.
Oh,